at least on this side, to keep it apolitique. But then again, the Honourable Minister for IT, as well as the Honourable Attorney General, could not resist the temptation to make it a political affair. So then, since they've opened the door, I will gladly oblige by walking through the open door. Precisely, and I very rarely, in this position that you wish me to stay in a long time for, I don't often have that opportunity and honor of having the last word, whereas the position of speech is sometimes monopolized by those in majority. So, allow me to say the following. The Honourable Attorney General, before I get to him, I will try to deal with what the Honourable Minister Balgobin has stated, the Honourable Minister for Information Communication Technology. Now, he has attempted to describe what exactly the identity cards are all about, as well as the mobile ID is all about. Now, it's the first time that it seems this motion has given him an opportunity of doing so. Whereas, when he had an opportunity to grab at the time
that the Finance Act of 2023 was being debated, did he then describe what he described today? The answer is no.
It is not now, at the time of a motion of disallowance, that uses for the ground of disallowance, one of them at least, being that it is a constitutional, technical matter that clearly the minister does not master, and it is not his fault. It's not his domain. But he sounded more like someone who is a salesman trying to sell his product to the people. That this is a good identity card, mobile or otherwise, 2.0, 3.0, whatever number you may put there, he is trying to sell his product. That's all he is trying to do. But it is not now that he should have embarked upon a sales pitch. He should have embarked upon a pitch to justify the reason to bring it in democratic society at the time when the finance bill was being voted. At no time did I say that the finance bill was unconstitutional. This is not the contention of this side of the House. We are saying it is that the regulation that he has brought is unconstitutional. That is the difference. Because the main act does not give him the power to bring such a regulation. Now, he has not been able to answer that part of the arguments put forward, precisely because it is not within his ability to do so, and that I totally respect. I cannot do certain things that he can do, and vice versa. Now, what's interesting though, is that the Honourable Minister for IT quickly passes over the definition of biometric data. Why does he do so? Statute, as Honourable Utim has said it, and I have to bring it back here, pour résumer, statute describes biometric data as, and I say it again what Honourable Utim said, any personal data relating to physical, physiological, or behavioral characteristics of an individual, which allow his unique identification. It's what Honourable Utim has said, and I'll go straight to the point. En résumé, biometric data also includes photograph. You cannot deny that. And what the Honourable Minister Balgobin seems to forget is that, one, there was no need for me to talk about mobile ID, because the point I made was that he was not empowered in law by virtue of the fact that there was a Finance Act that amended the National Identity Card Act of Mauritius, which did not obtain the three-quarters majority. Full stop. Section 47 of the Constitution was not complied with. And you will note, Mr. Speaker, sir, that the Honourable Attorney General, who unlike the Honourable Minister of IT, is well versed in law, did not comment at all on Section 47 of the Constitution. The argument put forward by me that the minister was not empowered to bring the regulation because there has been a breach of Section 47 that required a three-quarters majority vote since Chapter 2 was being amended. This has not been addressed by any members of government. Minister of the IT, Honorable Attorney General, none of them addressed that issue. The normal way of doing things in Parliament here is I'm a mover of the motion. The one who speaks immediately after me comes in to rebut my arguments. He didn't. Then Honorable Utim spoke, supported the motion, put in his arguments and developed new issues that I did not tackle. We expect the Honorable Attorney General, the main advisor of government, to come forward and rebut in law. But what he has chosen to do instead is to do what this government always does with panache. Look in the rear-view mirror, and because they keep on looking in the rear, they will clearly crash because they don't look forward. That's the problem. You see, when the Honorable Attorney General said, why did you not go for a constitutional challenge? Does the Honorable Attorney General pretend to ignore the fact that there is nothing that stopped us from going for a constitutional challenge, or anyone for that matter? But there is nothing that prevents us from coming as parliamentarians to the National Assembly precisely to go for the motion of disallowance, and also to show to the Supreme Court later on, for anyone who wants to challenge those two regulations, that precisely there has been a motion of disallowance, and during the debates of the motion for disallowance, there has been no argument whatsoever from the other side to come and defend the position that Section 47 has been breached. That is what the Supreme Court will see. And that is why we chose to come by way of a motion of disallowance. It was an opportunity for government to come and explain itself, or to stand up and say, I agree. It should be disallowed because we were wrong, because we did not intend to be, but it happened to be that we were wrong. Mr. Speaker, why is it that the Honorable Attorney General, who had an opportunity to expose his point of view and to rebut the arguments of this side, why is it that he chose to comment on the low tone of Honorable Utim? But he fails to realize that, forget low tone or low voice, he failed and was silent about the definition of biometric data. The point made by Honorable Utim, the Honorable Attorney General, was totally silent about that. And I interpret that, and the people out there should interpret this silence as an admission that he is wrong. You can say any amount of times that the Honorable Prime Minister is right. You can smile as much as you wish to say that he's right. You can try to convince yourself that he's right, but that does not mean he is. That is called arrogance. What I'm asking the Honorable Attorney General to do, and what people expected him to do, is to also take note that the person he says was right has not also uttered a single word to defend this motion or to attack this motion. He talks about the time of 2013 when Honorable Ganu was leader of the opposition, and I see the Honorable Deputy Prime Minister, Honorable Obi Gadu, smiling away, saying, oh yes, look at what they did in 2013. Oh God, very, very bad people. This is what he was doing, smiling, smirking, as though he also does not agree. But he forgets to tell everyone that he sat together with all of us in 2014, part of the same alliance. 14. I'm talking about 14. Were you not in the same alliance with the Labour Party? 2014, you've forgotten? So, if you today believe the Labour Party was so wrong, why did you agree to sit together in the same alliance in 2014? So it's so easy to make politics. When I try to keep this debate above board, you want to satisfy your ally by looking good and sharing their views today. But in actual fact, he sat together, shared same drinks, shared same views, and criticized the MSM in 2014. And today he smiles and brings us political hypocrisy. This was not my aim at the beginning of this motion. It was to keep it above board. Now you said you opened the door, now take it. Why do you not, the Honorable Attorney General, tell us? Doesn't the judgment of the Privy Council and the Supreme Court say that keeping biometric data, storing it, is a violation of the Constitution? We all agree on that. The Honorable Prime Minister agrees on that. He was right. Yes, he was right. But what's shocking is that when he was right in the judgment, he's forgotten what it was all about. Just simply today because his agenda is different. He was right. He obtained gain de cause. And what did this gain de cause say? The same application, the ruling and pronouncement as in the Mahadeo case. This is what Justice Balanci and other judges said. They said that keeping and storing of biometric data is a violation of the Constitution. That is law today because this is a precedent that is binding. So what the issue is, if the Prime Minister wants to waste taxpayers' money by getting all of us to go to court and lose the case later on, that is, posterity will judge him. But the issue is, are we not agreed, Mr. Speaker, sir, that keeping biometric data, storing of biometric data is against the Constitution? No one can deny it because the Supreme Court says so, the Privy Council says so, the Committee of Experts of the United Nations says so. So when all those institutions say so, how come the Prime Minister pretends to ignore that today? What is his agenda? Biometric data, photographs are also included in the definition. Any legal dictionary says that biometric data includes photographs. So why is it, if photographs consist of biometric data, why is it therefore that they are being stored through a confession on the part of the Honourable Minister of IT, through his intervention that he was so proud about? He confesses that this will be stored. The Honourable Attorney General agrees through his silence that it will be stored. And no one else on the side of government says otherwise. The regulation says it will be stored. The Supreme Court says it's unconstitutional, and what I have on the other side are gentlemen, ladies who want to politicize every single opportunity instead of seeing what is written in a judgment and understanding what's in that judgment. The Honourable Prime Minister says, prove me wrong, go to court. Fair enough. But then again, will not posterity say you have had an opportunity under Section 122 of the Constitution to reconsider your position? Under the Interpretation and General Clauses Act, you had an opportunity to reconsider your position. You failed. There is nothing more dangerous in life than someone knowing he's wrong, but insisting that he's going to proceed for the sake of politics. There is nothing more dangerous. If you ignored and were ignorant, I'd say forgive them. But this is knowingly doing something that is against the Constitution. That is condemnable. So, as I've said earlier on, Mr. Speaker, sir, when the judgment of the Supreme Court says at page 22 of the case of Mahadeo, for all those ladies and gentlemen on the other side, those honourable members who believe that what I'm saying maybe doesn't make sense or they cannot really fathom the intricacies of what I'm saying, let me refer to the fifth paragraph of page 22. I quote the Supreme Court judges saying, "We hold, therefore, that the provisions of the NIC Act and regulations which enforce the compulsory taking and recording of fingerprints of a citizen of Mauritius disclose an interference with the plaintiff's right against the search of his person guaranteed under Section 9 of the Constitution." The Honourable Minister of IT says, and the Honourable Attorney General says, it is an option, it is not mandatory. But the Honourable Attorney General fails to stop and listen to his own colleague. His own colleague, the Minister of IT, says, if you want to participate in the fast-moving digital modern world, then you can opt to go for a mobile ID, national ID. So if you choose to take part in a modern digital world, you want to be part of it, then you have the option. And if you have that option, you are obliged to comply with the regulation. So please, let's not play on words. So anyone in this country who wants to participate in a modern digital world has no choice but to give all information that forms part of the biometric data. That is what he's confessed. So his understanding of the law means if you don't want to participate in the modern digital world, don't. Stay out of it. But this is precisely a violation of Section 9. He's just confessed unknowingly. Posterity will look at this situation and say, knowingly, without any justification in a democratic society, you violated the Constitution and the judgments of the Supreme Court and the precedents and the Privy Council and what was decided at the United Nations. Violate it knowingly. Do it. Win the day. But you will be judged severely in the future and in the near future. Believe you me. That will be all.
So you're withdrawing your motion?
I'm not withdrawing the motion. I put it to the vote and let posterity decide. And I ask that it be voted upon, that motion, Mr. Speaker.
Mr. Speaker, allow me to make a point of order, Mr. Speaker, sir. And I will beg the indulgence of the House and of the opposition. Mr. Speaker, sir, although we have reached the early hours of the morning, I wish to raise a point of order, sir. It is now time for you to put the question on the motion, and I'm duty-bound to draw the attention of the House to Section 38 of the Standing Orders, which reads as follows. The question on any motion or amendment shall not be proposed from the chair, in the Assembly unless it shall have been seconded. But in committee, a seconder shall not be required. Sir, since the time the motion has been moved by the Honourable Leader of the Opposition, no member of the Opposition, and you can check from the record, has seconded the motion. We are now at the end of the debates, and the Honourable Leader of the Opposition has already summed up, and no member has seconded the motion. I will move, Mr. Speaker, sir, that no vote can be taken on the motion. I insist that Section 38 provides that the Speaker shall not propose the question on the motion if it has not been seconded. Section 38 specially mentions, Mr. Speaker, sir, that in committee, a seconder, I'm using the exact words of the standing orders, in committee, a seconder shall not be required, meaning that since now the House is not sitting in a committee, a seconder is imperatively required. Therefore, Mr. Speaker, sir, I move, according to me, it is a motion of the Leader of the Opposition which should be disallowed.
Mr. Speaker, in answer to what he has raised as a point of order, I have just confirmed from Honourable Udim that during his speech he seconded the motion. Full stop. So then, that's it.
Honourable Leader of the Opposition, I gave you a chance when I told you, do you withdraw your motion? And you said no. That question was to indicate to you that you haven't, neither you nor Honourable Udim, at no point in time, you have seconded the motion. No. So, Honourable Ganu is right raising this point of order. And I rule. Anyway, you are 4, 5 people here. You don't even have a quorum. You've been speaking because they formed the quorum. I don't know why the government, they have been listening to you, they formed the quorum,
You don't have a quorum, you don't have a majority, so what's the point of taking it?
Mr. Speaker, the quorum is on the House, not on what side.
No, I'm not saying the quorum in this side or that side. I say you don't have a quorum.
But we don't have to have a one quorum.
Yeah.
That of the Assembly.
I mean, you are only 6 people here.
So what?
You are only 6 people here, which means that if these additional members were not here, this House wouldn't have a quorum. This is my point. I won't want to discuss with you. Please, I have ruled. You did not second your own motion. Nobody seconded the motion here. And so I rule Honorable Ganu is right. And so I suspend the sitting unless the House is adjourned for...
It's time for... Mr. Speaker, sir, I move for adjournment of the House to Tuesday, the 7th of May at 11:30.
The question, let me put the question. The question that the House be adjourned to Tuesday, 7th of May at 11:30. Those in favor say aye, those against say no. The ayes have it. I suspend the House.